Welcome back. The LSK presidential debate continues. As I mentioned earlier, one question to all the panelists, and then we open it up. The audience can't wait to fire in those questions to the people from whom the person that will be the next LSK president will come from. All right, so that last question is on the man, Okiya Omtata, who some say represents the spirit of civil litigation. What do our candidates think about his style and how he operates? Advocate Harvey, I think this time let me start with you.
Well, at one point in time, I thought of making Okiya Omtata honorary member of the Law Society, because ideally he's done that which the society is supposed to do.
Is he a one-man LSK?
Of course, he's not a one-man LSK, but he's a spirited Kenyan. In the words of Dr. William Mutunga, is citizen Okiya when we appeared before the Supreme Court. But therein lies the major problem that has to be resolved by anyone who will be elected as the president of the Law Society of Kenya. You must pick a candidate who has a distinguished record of public interest litigation. Someone who will be able to act speedily as and when there is a transgression in respect of the rule of law and constitutionalism. Not that Okiya Omtata must be excluded from taking the role that he has performed excellently, but the primary role must be taken by the Law Society of Kenya. Ideally, this is what we are tasked to do under Section 4 of the Law Society Act.
Has the Law Society of Kenya failed to play that role?
I think the Law Society has failed to play that role.
You say that as you stand next to the current Vice President of the Law Society of Kenya. Can you say that facing her, if you could? Is that something that you're so confident of?
Yes, Madam Vice President. The Law Society ought to have taken a primary role in challenging the failure by the President of the Republic of Kenya to swear in those judges that were recommended for appointment by the Judicial Service Commission. The Law Society ought to have taken a role in challenging the unconstitutionality of the Contempt of Court Act, instead of taking the peripheral role of an interested party. Because it looks like we are running after the carpet time after time with members of the public, Okiya Omtata and my classmate, Adrian Kamotho, taking the center role. That should not be the case.
That should not be the case. Thank you for that. Advocate Tigai, go ahead.
Allow me to address the issue of public interest litigation. Let me say this, Wahiga. LSK is an institution. And as we speak, it functions within a particular strategy. And as we speak right now, we have the PIL committee. On matters PIL, they have to be channeled through the committee.
PIL, public interest litigation.
Public interest litigation. Allow me to speak on Okiya Omtata. It's within his right under the Constitution, just like any other Kenyan, to file a PIL matter in court. And he has performed exemplary well. But the question then is...
Even better than the LSK?
And the question then is...
Some would say.
Yes. And the question then is, where are the gaps? For me, it's very important. It's not for a particular advocate to go to court. PIL should be taken up by any lawyer cutting across anywhere in this country. The question then is, how do we institutionalize that? We need to have a robust mechanism where we work also with other institutions, and there are so many out there, the NGO world. We have GIZ, OSIA, and part of that committee also has our members within various institutions, and we came up with a very good legal aid guidelines. Now, it is important for us to institutionalize that document. And when we institutionalize that document, it's then simple. Let us have funds from other institutions cutting across board.
Okay.
You know, institutionalize these funds. Let us allow any advocate who's interested in practicing matters public take up these matters even at branch level.
Thank you.
And we pay them well for that.
Okay.
And that is the institution I would wish to drive when I become the president of the Law Society.
Advocate Kanjama, define, in your view, this man, Okiya Omtata.
Let me start by making a disclosure. Omtata likes saying that one of the advocates who taught him constitutional law was actually myself.
Okay.
And not in a formal way, but because he instructed me early in his PIL, or public interest litigation career. I represented him in a case where some land had been grabbed in Nakuru from Kenya Agricultural Livestock Research Organization. I represented him in a case where some land had been grabbed in Busia, were very successful. Hundreds of hectares were recovered and returned to the government. I was his lawyer. I've represented him in cases involving judicial appointment to introduce human resource practices and so on.
It sounds like you've had a close relationship with him.
So what I would like to say, what I would like to say is, he then took up and started filing cases on his own. And I would like to say Omtata is someone who should be commended as a very public-spirited individual. He actually does his litigation, he does his pleadings himself. I've listened to him arguing in court. I've been representing the Judicial Service Commission in one matter where he was on an interested party. His submissions were excellent. So what I would say is that he's doing a good job.
Is he filling a gap that the LSK should have filled?
Let me rephrase.
You sit as the Nairobi branch of the LSK.
Yes. The PIL mandate, first of all, is under the national office. But I want to say this. LSK is not the sole body entrusted with doing public interest litigation. We need more members of the public like Omtata. We also need more lawyers in the individual capacity like Omtata. But I would say within LSK, there has been a bit of a weakness. Actually, there has been significant weakness in the speed with which we engage in public interest litigation matters. At the branches, we've had to wage a battle first against the national office so that they can feel free to allow us as branches to also file our public interest litigation matters and not feel that we are threatening the institutional unity of the law society. So for example, at Nairobi branch...
And I'll take this as your last comment on this.
Yes, so for example, as Nairobi branch, we did file an appeal on the question of the right of land and employment cases to be handled in magistrates' courts to deal with the congestion in the special courts. We were successful. It is thanks to that litigation that members of the public and lawyers who are their representatives now can have their land and employment cases handled in magistrates' courts. It has caused tremendous transformation in dispute resolution in that space.
Okay, thank you for that. Advocate Meneka?
I think Omtata owes LSK a lot of gratitude. The LSK...
Not the other way around.
No, it does. The LSK is 71 years old. And the Law Society of Kenya was at the forefront for fighting for space, democratic space in this country. It is the same law society that we belong to today. It's not a different law society. We fought for that space. It is our brothers, our seniors who fought for that space that allowed Omtata and others, many others like him, including Kofek and other individuals, to file public interest matters. Having said that, it is not the preserve of the law society on its own to